Good afternoon, everyone. Welcome to our monthly Dallas Volunteer Attorney Program, CLE. My name is Kristen Solis. I am one of the mentor attorneys here at DVAP. And for those of you that are not familiar with DVAP, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their civil cases from start to finish. And one of the common types of cases that come through our office that we're always needing volunteers for are expunctions and non-disclosures. And this is the only realm where we actually enter the criminal world because these are actually civil cases in a criminal court. And the reason we do them is it because it removes barriers for our clients so they can get those charges off the record to get jobs, to get housing, that sort of thing. So today we are blessed to have Andre Craig with us to talk to us about how to do expunctions and non-disclosures. Andre is a proud graduate of Liberty University. He is currently an assistant public defender, um, basically focusing his time on felony domestic violence cases and specialty court cases involving youth. Prior to joining the public defender's office, he was in private practice, doing criminal defense and family law. He has taken a ton of expunctions and non-disclosures, and he is very experienced in this area. So, without further ado, I will turn it over to Andre.
Thanks so much, Kristen, and it's an honor to be here with all of you today. Yes, as Kristen said, I'm currently a public defender over here in Dallas County, and I have the pleasure of helping DVAP with the expunctions and non-disclosures aspect of their work. Without further ado, let's go ahead and get started. I've entitled this Expunctions and Non-Disclosures, the Basics. The core of what we're going to talk about today is I want to just kind of give you the general overview of the eligibility for clients in order to get expunctions and non-disclosures. Once you receive a case, make sure you delve into your particular case just to make sure that it is eligible. I wanted to give you a 1,000-foot view, as a lot of expunctions and particularly non-disclosures can be very convoluted depending on the case. But without further ado, let's go ahead and get started. And let's see if my computer will work with me. And there we go. All right, so what is an expunction? So an expunction, as Kristen said, is a civil process in which the petitioner seeks to remove information about an arrest, charge, or conviction from their permanent records. Now, in order to obtain an expunction, the client has to satisfy certain statutory requirements. It was initially in the Texas Code of Criminal Procedure, Chapter 5501, but with this last legislative session, they actually reorganized it and made it a lot more organized. It is now in CCP 55A, and we'll go through all of the individual types in a little bit. But once the expunction is granted, an expunction order doesn't become finalized or effective until 30 days after the order has been signed by the applicable judge. Generally, expunction orders are sent to a felony judge. The only exclusion to that is municipal court judges, but most expunctions are done through the felony court judges. Now, after the 30 days, the clerk's office in Dallas County will notify the respondents listed in the expunction order. So, and we'll go through that in a little bit, but literally it just kind of lists all of the individuals that have an interest in either retaining or destroying the information the expunction seeks to get rid of. And so in that 30 days, the clerks will notify all of those listed. And we'll send a copy of the final order to you, the filing attorney. And by that time, the respondent should be destroying all of the records related to those particular charges. In my experience, and just a practice tip, for those of you that are doing expunctions after that time frame has has lapsed, just make sure you can also send a copy of the order to any major criminal background reporting agencies that may not be listed in the order as well. Now let's talk about the grounds for expunction, and there are a number of them. So we'll go piece by piece. Acquittal at trial, a pardon, identity theft, no conviction and no probation except Class C's, Class C deferred probation, and certain unlawful carrying of a weapon convictions, which is relatively new, and we'll talk about that in a little bit as well. But we'll start with acquittal, and this is based off of 55A001 and 55A151. So first and foremost, the client has to be found not guilty at trial. It could be either a bench trial or a jury trial. It doesn't matter. And the client was not convicted of another charge within a criminal episode, which I'll explain in a little bit. And the client is not still subject to prosecution for another charge within a criminal episode. So if, in other words, if the client is either convicted of or is still subject to prosecution for another charge within a criminal episode, the acquitted charge is no longer eligible for expunction. So then that begs the question, what is a criminal episode? This is based out of the Texas Penal Code 301, which pretty much defines it. The literal definition is a criminal episode is multiple charges that result from a single arrest or a series of arrests over a period of time involving the same offense, and the district attorney determines it to be a criminal episode. For those who practice over in the criminal realm here in Dallas, we call that either within the same transaction, or like a string, for example, the example I put in here, string of thefts over a certain time frame. So that's kind of what a criminal episode is. So if the client is still subject to or is convicted of one of those charges deemed to be a criminal episode, the acquitted charge is no longer eligible for expunction. Next is pardon, based off of 55A03 and '04. Essentially, what this is if the client was convicted, but was later pardoned either by the governor or by an appellate court or something like that, based on actual innocence or another legal basis, they then become eligible for an expunction. But I want to make a note here. If the pardon is based solely on the actual innocence standard, the Code of Criminal Procedure requires that whether the pardon or the court order that deems it to be actual innocence, it has to specifically say that on its face. Otherwise, it won't be deemed eligible for expunction. And just for those that may be interested, I did a hyperlink to the Texas Board of Pardons and Paroles Executive Clemency page, which kind of helps you go through the pardon process, what the application looks like, and things of that nature. Next is identity theft, based out of 55A 006. Effectively, what this is if your client was, effectively, if a defendant uses your client's name falsely, and as a result of that false information, the client is then charged with that offense, and they were not guilty of it, and they weren't even in the same vicinity as that. The Code of Criminal Procedure allows them to actually get that expunged off of their record. But what the client has to do is have to, first of all, report the identity theft to the Dallas County Sheriff's Office. And hopefully, with the sheriff's office and the DA's office, they'll work together to get that off of your client's record. But the client does need to be made aware that if they do try to do it under this basis, they will likely have to provide fingerprints to compare to whoever the defendant actually was. But this is something I wanted to make sure you guys knew about. I've only had a couple of cases like that, but I wanted to mention that as well. All right, so this ground is, as you'll see, is one of the convoluted areas of expunction law. So I consider it a no conviction and no probation except Class C ground. It's based out of 55A 051 through 054. So there's a variety of different circumstances that a client may meet this requirement for expunction. So I'm going to go a little bit slower so to make sure everyone is following along with me on this. So first and foremost, the charge can no longer be pending against the client. That's just straight number one. Number two, The charge did not result in either a conviction of any kind or any form of probation, deferred or otherwise, unless it's a Class C deferred probation. And we'll talk about that, later in the presentation. But that's number two. And number three, one of these requirements have to be satisfied in order for the client to satisfy this expunction. Number one situation is the statute of limitations for the charge has run or lapsed. So if the client's of the charge that you're trying to get expunged, the limitations has run, then you're eligible for an expunction. And we'll talk about when that begins and ends in a little bit. Or the statute of limitations has not run and lapsed. So if your client's charge for the limitation for the charge has not run or lapsed, then there are some further requirements that need to be satisfied. So if it has not lapsed, then either the charging instrument, being the indictment or the charging information, has not been presented, and either the applicable waiting period has passed, which we call a limited expunction. And again, we'll talk about that later in the presentation, or the district attorney has certified that the records are no longer needed in any prosecution, including anyone that's not your client. So if the DA certify that they don't need the records for any purposes, then that's another way it could be satisfied. But that's entirely up to them. That's in their discretion. They're not required to do that. So that's one thing. Or if the charging instrument has been presented, it would have to have been dismissed or quashed for the following reasons. Either the client completed an approved pretrial intervention program. So like Kristen said, I do specialty courts for youthful first offenders. So this is the ground in which I use for my clients over here for their expunctions. There's mental health, there's veterans court. I do youthful first offender. So that's something that can work. Or the charging instrument was presented due to mistake, false information, or similar reason indicating a lack of probable cause that the client committed the offense, or the charging instrument itself was void. And of course, the case law creates a variety of different ways that could be possible. So that's why I say once you get a case, if it falls into that category, you have to do your part to figure out whether your particular circumstances fit or not. All right, so for the statute of limitations. So the statute of limitations begins from the offense date of the charge, but is told or paused once the charging instrument is filed. And it remains told until either the case is dismissed or, for felony purposes, is no billed by the grand jury. So, and I'll list what the applicable statute of limitations are. So for non-family violence misdemeanors, the statute of limitations is 2 years from the date of the offense. And then there's the Texas Code of Criminal Procedure 1202A. For family violence misdemeanors, it's 3 years, which is found in CCP 1202B. Now, for felonies, it actually kind of depends on what the particular offense is. So CCP 1201 actually lists a host of felony cases and whether they have a statute of limitations or not. And if they do, what is that limitation period? So just some things to kind of highlight. There are those felony cases that don't have a limitations period, such as murder, certain sex cases, and things of that nature. And when it comes to offenses that involve children, the limitations actually doesn't begin until the child victim turns 18. And so that's all based out of 1201. So if you have a client that has a felony charge that wants to get it expunged, that's where you have to go to see if the limitations has expired or not, if there is one. Now, like I mentioned, there's something called limited expunction, and this is based off of 55052A. And so pretty much what a limited expunction is it allows law enforcement to keep the records until the statute of limitations has lapsed. But if it's signed off on, the general public won't be able to see it, but law enforcement will still be able to keep those records until the statute has run. So the requirement for that is kind of just reiterating what I said in the prior slide. The charge can't be is no longer pending and did not result in either a conviction or probation, except for a Class C deferred. The statute of limitations has not lapsed yet, and the charging instrument has not been presented. And so, if that's the scenario, then one of the following requirements has to be satisfied. Either the district attorney, like I said, has certified they don't need the records anymore, but again, that's at their full discretion, or the applicable waiting period has passed. And so the applicable waiting period depends on the particular charge you're dealing with. If it's a Class C misdemeanor, you have to wait until 180 days have passed from the client's date of arrest. If it's a Class B or A misdemeanor, it has to be a year that has passed since the date of the arrest. And for felonies, it has to be 3 years have passed from the date of the arrest. And so if you get an expunction case and it might be a limited expunction, you have to see whether any of those applicable waiting periods have passed, assuming the DAs didn't certify for other purposes. All right, so for Class C misdemeanors, like I said, it's 55A051. So if the client has successfully completed deferred probation for a Class C misdemeanor, and for those that practice in the criminal courthouse, that even includes if the charge is then reduced to a Class C misdemeanor deferred. The case satisfies, and the case has to satisfy any other applicable statutory expunction requirements, then the client can get that expunged from their record. Now on to certain UCW convictions. Again, this was relatively new back in 2021. This is based off of 55A005. Um, so effectively, in this particular scenario, the client was convicted of a misdemeanor unlawful carrying of a weapon. That conviction is eligible for an expunction if the client was charged with this UCW under the former Penal Code 4602 as it existed prior to September 1st, 2021. And so what that statute looked like back then is listed here. So effectively, if your client had a conviction for a UCW, misdemeanor UCW, and is under this 4602A as it existed back then he or she is eligible for an expunction, but it specifically has to have been charged under this particular statute as it existed prior to September 1st of 2021. And the offense obviously had to have been committed before then as well. So cases that are generally not eligible for expunction, based out of CCP 55A 151 through 154, probation violations, as we talked about, criminal episodes, and interestingly, absconding or leaving the jurisdiction while out on bond. So that's that. And community supervision, probation, like I said, except for a Class C deferred misdemeanor. That's based out of 55A051. And of course, convictions minus the UCW cases we just talked about, also in CCP 55A051. All right, so once you have determined that your client is eligible for an expunction, I'll explain to you the filing procedures in Dallas County when it comes to expunctions. So first and foremost, each expunction filing has to include a petition for expunction and a proposed order for expunction. And if applicable, usually this is the case if you're taking a legal aid case, a statement of inability to afford court costs. So effectively, the client, we're asking the court to waive any filing fees for an expunction because they've been deemed indigent. The petition can include one or more case numbers and must be verified and signed by you or the client. Typically, with my expunctions, I verify it myself and have my legal assistant notarize. So that has been approved as well, but the client can do it as well. Now, when e-filing, the petition has to be the lead document and the proposed order has to be an attachment to that lead document. So two separate documents in the e-filing system. Now, if you have a statement of inability to afford court costs, that also has to be a separate lead document as well. So the clerks will kick it back if you don't file the petition as a lead document, the proposed order as an attachment, and the affidavit of inability to afford costs as a different lead document. Once it's filed, once it's accepted, you'll get a expunction case number. Usually it'll start with X dash whatever year it is, so 2025, and then so on and so forth. So once that's done, the petition will be given a hearing date, typically by the judge that it's assigned to. But prior to that hearing date, the assigned district attorney in Dallas County, the appellate division of the district attorney's office handles the expunctions. They'll either file a general admission agreeing to the expunction or file a general denial explaining any objections. So I've filed in the time that I've really been licensed, and even with legal aid, I filed a little over 200 expunctions. The only expunctions I've ever had objections to is the district attorney was either telling me there's another charge that I couldn't see on my end that's eligible, or I needed to correct like a police department or an offense date or something technical like that. But before the hearing date, you'll get notified of whether they agree to the expunction or they object to it for whatever reason. Now, if the district attorney agrees to the expunction, they themselves will take the proposed order assigned to the assigned judge to get it signed. You won't need to appear for that. And like I said at the outset, once it's finalized, after the 30 days has lapsed and all of that, you'll get a certified copy of it. And once the order becomes final, like I said, you will receive a certified copy of it to the contract address. Usually Dallas County sends it via email. They used to be way back when where they would mail it, but nowadays they email it to you. So make sure you put your email address on the filing on the petition. All right, and so here are some, if you wanted a model expunction template, I provided some links that had helped me early on. So there's the Texas Legal Help website, the Dallas County website. If you're getting a case from DVAP, you can reach out to Kristen or Catherine, the two mentor attorneys. And you can also email me as well, and that's my email address down there. All right, so that's it for expunctions. And so now let's talk about non-disclosures. So a non-disclosure is a civil process in which the petitioner seeks to seal a criminal record from public view. So the general difference between expunction and non-disclosure, an expunction completely erases the record even from the government as if it never happened. A non-disclosure, if granted, merely just hides it from the general public, but law enforcement and certain other organizations still get to see it. So that's the main difference between an expunction and non-disclosure. All right, so there are some general requirements for most all non-disclosures you have to file, and this is based out of the Texas Government Code 411074. And so going forward, non-disclosures are highly convoluted and very case specific. And so I try to be as thorough on here as possible. So let's go ahead and go through the general four basic requirements for all non-disclosures, with the exception of ones under 4110728 and 29, which we'll talk about in a little bit. But first, the client must not have had a prior conviction or deferred probation, including the case they're trying to get disclosed, on any of these following offenses. And so if they have to register as a sex offender, aggravated kidnapping, murder, trafficking, injury to a child, abandoning or endangering a child, violation of protective orders, court orders, bonds on family violence cases, sex abuse, stalking, trafficking, any family violence cases. The client cannot have any prior convictions for those things or deferred probation, including the particular offense that they're trying to get non-disclosed. Second, the client must not have received an affirmative finding of family violence on the case that they're trying to get non-disclosed. So if it's a family violence case and an affirmative finding is found in the court, then that's not going to get non-disclosed. Third, the client must not have received a conviction or deferred probation from the time client was sentenced or during any applicable waiting period, which we'll talk about. So every different kind of non-disclosure has a certain waiting period before you can file for one. And I'll talk about that as we get to all of the different ones. But during that time period, and even while the client is on probation or has been sentenced, they can't receive anything else during that time frame. And lastly, which is usually the catch-all, the granting of the non-disclosure has to be in the best interest of justice. Okay. All right. So that's the general requirements for every non-disclosure, with the exception of the two that I noted at the top, and we'll get to those eventually. So here are the types of non-disclosures: deferred probation for certain nonviolent misdemeanors, deferred probation for felonies and certain other misdemeanors, deferred probation for certain DWI, driving while intoxicated or boating while intoxicated misdemeanors, completion of veterans treatment court program, certain victims of trafficking of persons or compelling prostitution, deferred or straight probation for certain veteran clients, straight probation on certain misdemeanors, straight probation on certain DWIs, convictions for certain misdemeanors, and convictions for certain DWIs. So I'll go through those individually as we get to them. So first, we'll start with the deferred probation for certain nonviolent misdemeanors. Again, this is the Government Code 411072, where this comes from. The client has to have completed a deferred probation for a misdemeanor other than the following misdemeanors. So I won't go through those individually. But if the particular case they're trying to get non-disclosed, it cannot be under these sections of the penal code under this section. Additionally, the client has to have been a first-time offender. And you'll see that a lot with a lot of these non-disclosures. But that doesn't include any traffic offenses, so effectively Class Cs. But anything else, he or she cannot get this unless they are a first-time offender. Also, for this particular section, the client must have completed deferred probation on or after September 1st of 2017. The reason they have that date is because the statute was amended at that time to add additional things, and so that's why they put that requirement there. And the court did not make an affirmative finding that it is not in the best interest of justice for the client to receive a non-disclosure under this section. On to the next one. And let's see if my computer is froze on me. Okay, here we go. Deferred probation, felonies, and certain other misdemeanors. That's under Government Code 411072. So the client must have completed deferred probation either for a felony, or if it's for a misdemeanor, it can't be a DWI or a BWI, and it has to have not been eligible for non-disclosure under the prior section we just talked about, 411072. If it's a felony, your waiting period, the client's waiting period is 5 years since the client completed probation. If it's a misdemeanor, it depends on what penal code section it is. So if it's for any of these misdemeanors, the client has to wait 2 years after they have completed probation for that misdemeanor. And if it's not a misdemeanor listed under there, then they can file it immediately after they've completed probation. But like I mentioned in the prior section, that whole waiting period, the client cannot be convicted of or placed on deferred adjudication on for anything during that waiting period. The next one is deferred probation for certain DWI, BWI misdemeanors under 411072. So the client must have completed deferred probation for a misdemeanor DWI under Section 4904 of the Penal Code, or misdemeanor BWI under 4906 of the Penal Code. Again, the client must be a first-time offender, excluding Class C misdemeanors. And so the DWI, BWI must not have resulted in an accident involving any other person. That includes if the client had a passenger in their vehicle, and it's irrelevant whether anyone suffered any injury or not. There cannot be an accident involving another person. Additionally, the client must not have had a CDL at the time or a permit at the time of the offense. The client must not have had a BAC or blood alcohol level of 0.05 or above. Interestingly, though, I found some case law that, especially if anyone practices DWIs and BWIs, if in the plea agreement you actually get the 0.15 language stricken and the client just moves forward on a class B, the Texas Appellate Court in Fort Worth actually held that because of the striking of the 0.15 and the client met every other requirement, that was eligible for expunction. So that's the importance of plea negotiation in that aspect. And again, the court must not have made an affirmative finding that it is not in the best interest of justice for the client to receive a non-disclosure under this section. And the waiting period for that is 2 years after the client has completed probation. All right, now on to the completion of Veterans Treatment Courts under 411027. The veteran client has completed an approved Veterans Treatment Court for really any offense other than one that involves the operation of a motor vehicle while intoxicated. And the veteran client must not have a prior conviction for any of the offenses listed in Article 42A054 of the CCP, which those that practice in the criminal law are we usually deem those 3G offenses when a judge, the limitations a judge has on giving probation. And it can't be a sexually violent offense as defined by 62001 subsection 6 of the CCP. And the veteran client must not have been convicted of any felony offense during this particular waiting period, which is 2 years after the veteran client has completed their treatment program. Now, certain victims of trafficking of persons or compelling prostitution, and this one is a little bit unique as well. So this is based off of Government Code 4110728. So in this particular case, your client/victim completed either a sentence or probation for offenses under these sections of the Penal Code or health and safety. So felony or misdemeanor prostitution, Class C or B theft, Class B delivery of marijuana, or Class B possession of marijuana. Those are the limited charges that they may be eligible to get non-disclosed in this circumstance. Now, the client victim must have committed those offenses solely as a victim of an offense under these sections, so trafficking and compelling prostitution. So the reason they committed the offense was only because they were victimized under those codes. Additionally, so the client and victim must have, at the request of law enforcement or the DA, the client victim must have aided law enforcement in the investigation or prosecution of the defendant in those trafficking or compelling prostitution cases, unless the victim's failure to aid was due to a legal disability, such as the client's age, a physical or mental disability that also resulted from them being a victim of those offenses. The client victim does not have to satisfy the threshold requirements that I mentioned back in section 411074. So when I said most expunctions or non-disclosures have to satisfy these lists of things under this statute, the client does not have to meet those requirements. Now, if the client does, if you file on behalf of a client like a second or subsequent petition for non-disclosure under this section, the client must have committed the offense that you're trying to get non-disclosed subsequently prior to submitting of the first petition under the section. And then next is veterans placed on community supervision 4110729. The veteran client completed either deferred or straight probation on a misdemeanor. And specifically, in the process of completing probation, the client completed an approved veterans reemployment program as established by the CCP under Chapter 42A, Subchapter H1, and it was approved by the court. And the client, again, like I said, for the victim trafficking client, veteran clients under this section, they don't have to meet the threshold requirements under 411074 to be eligible for the non-disclosure under this section. And the waiting period for this is actually immediately after the veteran client has completed the program, as well as probation as well. All right, on to straight probation for certain misdemeanors. That's based off of 411073. So the client must have completed straight probation for a misdemeanor other than the following sections here. So DWI, FWI, BWI, et cetera, et cetera. Again, the client must be a first-time offender. Like I said, you'll see that a lot, specifically for the DWI cases too. But they have to have been a first-time offender, excluding Class C misdemeanors. Now, the waiting period for this is depending on whether there's an interlock condition or not. So if it's or correction, so the waiting period is 2 years have passed since client completed deferred or probate straight probation for a misdemeanor under the following sections of the penal code, which is listed there. If it's not under there, then the client can get the non-disclosure immediately after completing probation. Straight probation for certain DWIs. This is where I meant there's an interlock requirement. Depending on whether there's an interlock requirement, determines what the waiting period is. But this is 4110731. Client must have completed straight probation for a misdemeanor DWI under 4904 of the Penal Code. Again, client must be first-time offender, excluding Class C misdemeanors. The client must not have had a BAC of point 0.15 or more, but again, I think an argument can be made based on case law if you get that language stricken and client meets every other criteria that you could potentially get a non-disclosure on that. And the court must not have made an affirmative finding that it is not in the best interest of justice for client to receive a non-disclosure under this section. Now, the waiting period depends on whether there is a condition of interlock while client is on probation. If so, then it is 2 years have passed since client has completed probation, and during that time frame, client completed the interlock device requirement for at least 6 months. If either there is no interlock requirement or the compliance was less than 6 months, the client has to wait 5 years after they have completed probation. So convictions for certain misdemeanors, that's under 4110735, where the client is convicted of a misdemeanor other than ones under these codes. Again, client must be a first-time offender minus Class C misdemeanors. And the particular charge that they're trying to get non-disclosed under this section, it must not be eligible for a non-disclosure under the prior section we talked about, 411073, for straight probation for certain misdemeanors. And the charge cannot be sexual or violent in nature. The only exception to that is under like a basic assault under 2201. And now the waiting period for that is immediately after client has completed the sentence for a misdemeanor if it's a Class C. For Class B or A, then they have to wait about 2 years after they have completed the sentence for a Class B or A misdemeanor. So convictions for certain DWIs, that's under 4110736. The client was convicted of a misdemeanor DWI under 4904 of the Penal Code and is not eligible for non-disclosure under 4110731, so they didn't get straight probation for this. Again, client must be first-time offender minus Class C misdemeanors. Client must not have had a BAC of 0.15, but again, I think an argument can be made if it gets stricken and they meet every other requirement. The client's particular DWI must not be eligible for non-disclosure under 411073. Again, the court must not have made an affirmative finding that it is not in the best interest of justice for client to receive a non-disclosure under this section. And the waiting period for that, again, it depends on the interlock requirements. So it's 3 years if a client had completed their sentence and had at least 6 months of compliance on an interlock. If there was no interlock requirement or it was less than 6 months, they have to wait 5 years after they completed their sentence. So that is all the the non-disclosure requirements. And so let me tell you about how to file for the non-disclosures. So each non-disclosure filing, like pretty similar to expunctions, is petition, proposed order, and statement of ability to afford costs if it's applicable to your case. Now, what's different, however, is for non-disclosures, they have to be filed within the same court under the same cause number that put client either that convicted or probation or whatever the case might be. Uh, now, when it comes to expunctions, you can file more than one case number in one petition. Not so for non-disclosures. For non-disclosure, you have to file a petition for each individual case that you feel is eligible for a non-disclosure. And if possible, depending on whether it's a conviction or a probation, you have to attach the probation/conviction judgment and proof of completion of those things to the petition as well. Most of the non-disclosures I've received have been pre-Odyssey, and Forbes isn't running anymore. And so I'd have to do a Dallas County records request for those things. It was like pre-2013 or something like that, I think. But for each individual case have to be individual petitions. So when you e-file, the petition has to be a lead document. The proposed order has to be an attachment, just like expunctions. And same thing, affidavit has to be lead document as well. Now, after you filed, usually in Dallas County, when you file a non-disclosure, it'll have a separate non-disclosure number, which is usually CL dash whatever year, so on and so forth. Um, the petition and proposed order will be sent to the assigned district attorney. The assigned district attorney will either file an agreement or an objection to the non-disclosure. Like expunctions, if they agree to the non-disclosure, the DA will often will take it down to the judge for signature. You won't need to appear for that. Now, if they do object to the non-disclosure and it's something beyond clerical stuff, you will have to set the non-disclosure set for a hearing. And so for model of non-disclosures, like I did for expunctions, you can go to the Texas courts website that I posted there. If you get a DVAP case, you can email Kristen or Catherine, and you can also email me as well. So I know that was a lot of information, but thank you guys for having me. And I guess, Kristen, we can open it up to questions.
Thank you, Andre. That was a great presentation. We do have several questions, so we're going to go ahead and I'll go ahead and read those off for you. Question
Okay.
number one. How long does a person who was charged with a felony that got reduced to a Class C deferred have to wait before filing an expunction petition?
Okay, so the fel and make sure I understand. So it was initially charged as a felony, but ultimately gets reduced to a Class C misdemeanor, and they completed the deferred probation.
Correct.
Okay, so then they should be able to file upon completion of that Class C deferred under the expunction statutes. Typically, the expunction statutes, assuming, of course, it kind of depends on what ground they're going to do it. If it's a statute of limitations thing, they have to make sure the statute is run. So that's why it's important to look in that particular case, especially since it's getting reduced to something. Make sure they follow with the statute to make sure all the applicable requirements like statute of limitations and things of that nature have been met as well.
Great, thank you. Next question. Are there expunctions or non-disclosure relief at the federal level?
That I don't know. I haven't had personal experience with that. The only time I've ever heard, so typically expunctions and non-disclosures are state level, and technically the federal government doesn't have to abide by them. So I don't actually know if there's a federal companion to the state statute. So that I actually don't know. Kristen, do you know?
It is my understanding that there's not any relief for expunctions and non-disclosures at the federal level. I could be wrong, but that is my understanding.
Okay, that's kind of what I was thinking too, since expunctions are typically state specific, but I don't actually know that 100% for sure.
Next question. How often do judges make these affirmative findings that it's not in the interest of justice for non-disclosure of a particular offense?
So in my experience, it hasn't been really often at all, really. And so I guess the only circumstances that probably would ever happen if the case is egregious enough in the judge's eyes. But in my experience in the non-disclosure, and I've done a little over 20 non-disclosures. In either of those cases, the judge has never had a specific affirmative finding of non-disclosure. Not to say they don't, because that's why it's in the statute, but in my experience, I haven't come across any.
Perfect. Next question. Where would you go to look at all the convictions for expunctions?
So what you can do is, so what you can do in, because over here in Dallas, I have the ability to, as a public defender, I can look up at least the Dallas County specific stuff. Now for Texas wide, you can go to DPS, and usually if you're getting a DVAP case, their intake sheets, usually the mentor attorneys, usually will send in the packet. They've already done a Texas DPS run on them. And generally, the mentor attorneys have already kind of gauged whether the case is eligible for expunction and non-disclosure. But the Texas DPS website has some ability for you to actually do a run of a particular client's criminal history, Texas specific, for a fee. I don't know what that fee particularly is, but generally, if you're getting a case from DVAP, they've already done that for you, so you don't have to worry about that.
Next question. What's conversion disposition on an assault?
Conversion disposition on an assault. I would have to see that in particular, that particular
Okay.
case. So whoever sent that message, if you could email me directly, that would be great. So I can kind of, I think I've heard that terminology and I think I know what it is. But before I say it, I need to actually look at it first. So whoever that is can email me directly about that and we can look at that together.
Okay, thank you. Regarding the waiting period for non-disclosures, when the client was released early from deferred probation, does the waiting period begin upon the order granting the early release or the original date of probation expiration?
That I would argue if when they were released early, the judge signed a dismissal order granting discharge of successful completion, I would argue that's when it starts and not what the original one was. So the waiting periods typically specifically say about it's whenever the judge actually signed a dismissal order granting successful discharge, which oftentimes usually is whenever probation is supposed to expire. But that would be my argument is if the client is being released early successfully from probation and there's a court order dismissing the successful discharge of the client, then I would argue that's when the waiting period begins.
Okay. Next question. Do expunctions need to be disclosed for immigration applications? How do expunctions affect immigration?
Oh, now that I don't know. So at the public defender's office, we have a immigration specialist that answers that kind of question for us. Um, so I honestly don't know how that works. The only thing I know about that is immigration, even deferred probation and stuff like that, is it can be a negative consequence on immigration. But as far as expunction disclosures and stuff like that, that I don't know the specifics to. So whoever asked that should for that particular client should consult with an immigration attorney on that aspect.
Okay. Does an expunction petition have to be filed in the county where the original charges were pending?
Yes. And so for that in Dallas County specifically, whether it's a misdemeanor or a felony, it's actually filed with the Dallas County District Clerk's office. And then it'll get assigned to just a random not federal, felony judge for petition. But yes, it does have to be filed in the county in which the charges come from, because that's where the courts have their jurisdiction is county specific or wherever the charge came from.
Okay. Next one. S- second DUI in Texas, first was in Arizona. The question is, client would not be able to get an expunction or non-disclosure on the Texas DUI? Question mark.
So is the Texas a DWI? Oh, so is the Texas charge and clarification, is the Texas charge a DWI second? Is that what it came,
Yes.
or it was DWI second over in Arizona?
Mhm. Yes, Texas is the second DUI.
My argument would be no, because technically at that point the client is not a first-time offender, which is why they are being charged with DWI second. Of course, that particular attorney can because again, there's so many statutes in there involving DWIs. But if it's a DWI second, my gut reaction is no, because at that point, your client is not deemed a first-time offender, which is what is required for that.
Um, Next question. Are family violence cases that are reduced to Class C family violence cases or originally charged as a Class C family violence case eligible for expunction or non-disclosure if the case is a deferred adjudication for Class C?
So easiest answer for non-disclosure is it depends on if it's reduced to a Class C. It depends on whether there's an affirmative finding. And for those of you that practice frequently, those affirmative findings, DAs typically don't like getting rid of those. But that's what would make or break in a non-disclosure context. If that particular case is there's still an affirmative finding of family violence, that's not going to be eligible for expunction because that violates the threshold requirement for non-disclosures. Expunctions, again, if it's reduced to a Class C, and completion of deferred adjudication, and is dismissed after being reduced to a Class C, I believe the answer would be yes on that on the expunction context. But again, it would have to be a Class C deferred, and the client successfully completed that Class C deferred. And Kristen, would that be your understanding as well?
Yes, I believe so.
Okay.
Okay. And then last question that I see, the Department of Transportation filed into my expunction case and informed me that I needed to file a non-disclosure instead. My client had a Class A possession of controlled drugs and did the pretrial diversion, but could not get an expunction after successful completion because of DOT interpleading. Any suggestions for next step, as it's another $400 filing fee and my client does not have that?
That's interesting. I haven't had that situation before. So the client had a Class A, completes a pretrial intervention, which I'm guessing it was a kind of pretrial that didn't require probation. It was just a straight up dismissal. I haven't had that situation. Kristen, have you had that situation before?
I have never seen that situation either. My gut reaction would be if the judge hasn't ruled that the expunction is can't be granted, is to set the thing for a hearing. And of course, you're basically doing battle with the Department of Transportation at that point. But
Right.
yeah, I
Right.
have never seen that before.
Yeah, and I would agree with that. That particular client, if the client is eligible for expunction under because of the pretrial intervention, again, assuming, well, obviously it's pretrial intervention, so it wouldn't have been probation or anything. So I would say probably likely set that for a hearing, because I haven't had that experience before either. But the client, based on those just basic facts, if they completed a pretrial intervention for a Class A and successfully completed it, which resulted in a dismissal, then they should be eligible for expunction under Texas law.
Okay, and then let me don't see, oh, one more, sorry. Oh, so it was Ellis County for further clarification on the previous question.
Okay, so yeah, they'd have to set a hearing with the Ellis County judge, whoever is, because I'm assuming since they filed it, it should have already been assigned to a felony judge out in Ellis. So maybe if they can set a hearing with that Ellis County judge.
Great. Thank you. And I'm not seeing any further questions. So if anyone has any questions, please feel free to put it in the Q&A while we wait for additional